of their presentation, but also their timing. I mean, they've all of them stuck to time. So thank you very much. And that, of course, I would say is a trend we are going to insist on for the rest of the weekend. So just so that we're clear about that. Now, we have about 15 minutes, and we have open to the floor to ask questions of any of the experts that have just presented. Over to you. Would you, if you want to ask a question, would you put your hand up? And when you stand up, when called to ask a question, would you please identify yourself? Is there a question? Tom.
Thank you, Mr. Chairman. Tom Burke. I'm not sure if it's appropriate to ask the question, but I'll try anyway. As I understand it, the Constitution doesn't define marriage or family. It doesn't prohibit same-sex or unions. If so, is it appropriate and necessary to amend the Constitution? Should it not be dealt with in the legislative process solely? As I understand the process from this convention, assuming the convention recommends same-sex union, and assuming the government accepts that recommendation, there will then have to be legislation to allow a referendum, which, if passed, will then require legislation. Have we too many steps that are not needed? Also, is it appropriate to have the issues in the Constitution? If we look at Article 41(3)(1), the state pledges to protect marriage, and the following sub-article, the state or the Constitution permits divorce. They would seem to me to be in conflict. And are we possibly building up problems in our Constitution and making our Constitution too unwieldy? Should we be just dealing with kind of higher level things in the Constitution and letting the legislature do its work?
Okay, thank you. Thank you, Tom. I think that is probably a question that Jerry would possibly like to deal with.
Yes. Again, I just want to make it clear that I'm just trying to give my view as to where the state of the law is at the moment. It is true to say that the Constitution doesn't expressly define...
Jerry, could you get closer to the mic, please?
Yeah. It is true to say that the Constitution doesn't expressly define marriage. My view of the case law which is there, which is not perhaps definitive in the sense of absolutely having decided the issue, but my view of the case law is the case law indicates and tends to the view that the Constitution is premised on a marriage between people of the opposite sex. But to address the question specifically, I think what is suggested is that there would be an express provision in the Constitution. So even if one could argue that it's there now, and as I said, my view of the case law is that doesn't seem to be what's emerging, this would put it beyond any doubt and would make it clear. And equally, as I've said, depending on the wording of any amendment, if it was a directory amendment, it would tell the state, it'd say the state shall, by its laws, provide for same-sex marriage. So it wouldn't be a question of discretion. It wouldn't be a question that... So I think hopefully that answers your question, that it would put beyond any doubt what is the obligation of the state in the area.
Okay, thank you very much.
Thanks, Chairman. Seamus Kerr. Just two brief questions. The first is for Dr. Fennell. Under the Guardianship of Infants Act 1964, the provision for the testamentary guardianship being passed on, the issue of the rights of grandparents, where does the superiority lie in those circumstances? The second question is, Dr. Eimear Browne, in a same-sex marriage situation where there is a subsequent divorce, what are the implications for adoption and guardianship in those circumstances.
Just to address the question in respect of testamentary guardians, that's provided for under Section 7 of the 1964 Act, and that basically allows either or both guardian to appoint another person in the event of their death. And in the event of any disagreement between the surviving guardian and the testamentary guardian, that's a matter that has to go before the court. If it goes before the court, it will be governed by Section 3 of that same Act, which provides that the welfare of the child is the paramount consideration, and that will be the test that the court deploys to resolve any difficulties as between any kind of conflicting rights. In terms also of the rights of grandparents, it can arise in the context of Section 11B of that Act in respect of access, whereby members of the extended family may apply for access rights. And as I explained in the paper, that is a two-stage process that currently categories of people like grandparents would have to go through. Now, that may neither be here nor there in the event of same-sex marriage being introduced, because grandparents is an issue that can arise in either event, as is presently, or in the event of same-sex marriage. So it may be the legislature wouldn't consider that that is particularly necessarily appropriate to same-sex marriage only, and it may not be changed in that respect.
Thanks, Sarah. David.
Sorry. Thank Hi, my name is David Cullinan. Just a quick question.
Sorry. I beg your, could you hold on? There was a second.
The second question, sorry. Your second question was actually a very important question. What happens in the event of divorce or breakdown of the same-sex marriage? From a study of the countries where same-sex marriage is allowed, and the parents in those relationships both acquire or both have perhaps automatic parental responsibility in respect of the child. When the relationship breaks down, they retain that parental responsibility. So much like in a situation in Ireland, if a couple got divorced, the parents break up, but both parents retain their rights in respect of the children. In countries that allow same-sex marriage, that is the case with the same-sex couple also. Was there something more specific than that, or just the other? I suppose one other thing to mention is just in the paper there are a few examples of cases where that very thing happened. There's a Spanish case and a UK case where a child was born via a sperm donor to a female same-sex couple. Obviously that child was genetically only the child of one of those ladies, not of both of them. It couldn't be the child of both of them. And when those relationships broke up, the biological mother tried to argue that her special biological DNA link made her effectively the sole parent. The Spanish court and the UK courts disagreed with that approach, and they did grant parental rights to the other parent, even though they didn't have a genetic link to the child. I hope that helps.
Thanks, Eimear. David.
Thank you. Just a very quick question.
Could you introduce yourself?
Sorry, my name is David Cullinan. Just a quick question to Eimear, if I can. In any of the research that was carried out in countries where same-sex marriage does exist, is there any evidence to support the claims that this has led to a coercion of any of the religious organisations or orders, or in any way can act as a violation of the freedom of religion? So is there any evidence to support that claim, which is often made by opponents of marriage equality, in any of the research that was carried out?
Okay, good question again. Generally speaking, in Europe, or especially in countries like France, there can be a sort of I suppose, to some extent, a disconnect between church and state, to the extent that, as you probably all know, if you got married in France and you wanted a church wedding, you have to get married twice. So there are countries where that sort of a thing applies, and therefore, obviously, there wouldn't be coercion in France if they were to introduce same-sex marriage. In the countries that I looked at, marriage was very much regarded as kind of a civil law concept. So, therefore, really, it's a matter for the state to sanction that relationship. Now, the UK have a bill at the moment that I'm sure you've seen in the press. Their bill is a little unusual. They plan to legalise same-sex marriage such that you would be entitled as a same-sex couple to marry in a registry office, and they would leave it open to such churches or religious organisations as agreed with same-sex marriage that they could also officiate
and solemnise those arrangements. So say, I think the Quakers have indicated that they would be happy to carry out those kind of marriages, then they could perform those marriages. So they can opt in. Now there's an exception in the UK legislation, either in favour of or against, depending on your view, two churches, the Church of England and the Church of Wales. They're given a special established position in England, whereas in Ireland we don't have any religion that's deemed to be more special than the others. And under the UK bill, the Church of England is automatically excluded, the Church of Wales is automatically excluded. So they could not legally carry out same-sex marriages. There would have to be further law to allow them to opt in. And I think that's, I suppose, an effort on the part of the UK legislature to be sensitive to various legal and religious positions. I don't think, certainly didn't come across any example of any religion being obliged to carry out a marriage, and I don't think it would be possible given freedom of religion and other rights.
Okay. Any other questions before we move on? We have time for one more question if there's... yeah. Mike, please, again, Ronan, could you introduce yourself?
Thanks, Ronan Mullen. Could I just ask you very briefly, thank you very much for all your presentations. In relation to the issue of guardianship in particular, in the current situation, assuming there's no change, is there scope within the law in Ireland comparing, for example, a child that has been brought up in a situation of a second marriage to allow guardianship, for example, to the stepfather or stepmother in that situation, either with the consent of or without the consent of the biological parent not in the relationship? And how would that compare with the situation of civil partnership? What I'm trying to get at, is there a situation where without a constitutional amendment the court or the law could be changed, for example, to allow the court some discretion around guardianship rights and responsibilities in the case of same-sex partnerships, or indeed in the case of opposite-sex couples, in the case of second unions and so on?
I mean, I think the obvious answer is, first of all, it's always open to the legislature to amend existing legislation, even in the absence of a constitutional amendment. So should the legislature deem it appropriate to amend the 1964 Act in that regard, that would be open to the legislature to do so. I think the point that I was making in the paper is that in the event of same-sex marriage going through, that in turn raises questions of legal parentage, and it's difficult to separate the distinction between legal parentage and guardianship. And so in that respect, one would imagine that there would have to be something specific in terms of the definition of parentage linked then to concepts such as guardianship and custody.
Could I perhaps say something about that? As I understand the law at the moment, what I might describe as a third party can't be appointed a guardian. The law could be changed to allow for such a situation. I think, however, in the context of the discussion today, the important word there is could be changed. If there was a constitutional amendment in certain ways, it mightn't be a question of could, it might be a question of must.
Thank you. I think we're going to draw this particular session to a close. We will have when you move into roundtable discussion in about 40 minutes or so, you will have access to Jerry, to Eimear and to Sarah, as well as a couple of other people, lawyers who are here. So I think we're fortunate in that regard.